Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Cathay Y.N. Smith, Associate Professor of Law at the University of Montana Blewett School of Law. We will discuss her article, Creative Destruction, Copyright's Fair Use Doctrine and the Moral Right of Integrity, which is published in the Pepperdine Law Review. So, welcome to the show, Cathay.
Thank you, Brian. I'm happy to be here.
Yeah, I'm really glad to have you on because, we talked about this paper a little bit on Twitter, and I got to say, Vera is a special interest of mine, and I got to send out a big thank you to you as well, because while reading your paper, I came up with an idea for a paper I think I have to write myself. So you totally inspired that. And it's a great paper. I really like it. I think it's really creative. And it was something that I'd been thinking about. And I'm so glad that you wrote it first, because I think you did a better job than I would have.
Oh my gosh, Brian, thank you. And I'm honored to inspire your next work. Awesome.
Well, so for listeners who might not be Vera enthusiasts or moral rights nerds like the two of us, I wonder if you could start out by talking a little bit about the concept of moral rights in relation to copyright, and specifically the right of integrity that you talk about in the paper. What are moral rights? What is the right of integrity? Where do they come from, and what are they intended to do?
Right. So moral rights, generally, they're described as rights that protect an author's personality, an author's honor, and some people even say are there to protect an author's soul in their work. Oftentimes it's described as non-economic rights, right? So unlike copyright, which allows an author or the copyright owner to sort of collect licensing fees for the reproduction or use of their copyrighted work, moral rights actually are independent from the copyright or even the property rights in an author's work. And so, for instance, an author can retain moral rights in their work even after they've sold the physical copy of the work, and sometimes even after they've sold sort of the copyright, they've assigned the copyright to the work. They originated in Europe. A lot of people trace it to France, although I have definitely read a couple articles that have found actually some moral rights language in cases earlier than that in German courts. But generally, trace it to Europe, and then have since been adopted by countries, both civil as well as common law countries. Moral rights typically will protect the right to attribution. And so an author's right to be named as the creator of a work. They can protect, in some instances, can protect the right of disclosure and withdrawal. So an author can say, I want my work now removed from the public. And also the right of integrity is also another very common moral right in a lot of countries' moral right legislation, which gives an author the right to prevent sort of the distortion, the alteration, and sometimes the disparagement of their work. And this, of course, is even after that author has transferred or sold sort of the physical copy of the work as well as the copyright of the work. And I guess when we talk about FARA, that is the US's sort of adoption of moral rights under federal law here in the US, which is much more limited than European moral rights legislation.
Well, so the classic sort of statement of moral rights, or sort of the classic sort of articulation of the need or the obligation to protect moral rights, comes under the Berne Convention, and sort of like, as you say, articulated by France and many other European countries. I mean, I wonder if you could give some examples of what that would mean in practice, specifically in relation to the right of integrity, which is really the focus of your paper, like in a sort of European kind of Berne Convention
Yeah.
kind of conception. Like, what would that look like? What would it mean for an artist to assert a moral right of integrity, and who's entitled under the Berne Convention to assert those kind of rights in the first place?
Right. If we're talking about a broader, more expansive sort of moral right of integrity, which is attempting to protect a work from mutilation, modification that will harm the reputation or honor of an original artist, some really fun examples arise in Europe. But again, I want to clarify that this is under a more expansive view of moral right of integrity, which the U.S. didn't ultimately adopt. But moral right integrity could potentially, for instance, prevent a homeowner, and this was a case in Germany, can prevent a homeowner from hiring a second artist to paint clothing over the nudes in a mural in that owner's own house. It can potentially prevent, and this happened in Sweden, right? It can prevent, for instance, even the display of an artist's work next to highly offensive or highly pornographic photographs. It can prevent an artist's work from being cut up into pieces and sold separately, right, against that artist's will. And so in Europe, the right of integrity is much more expansive in that it doesn't just prevent a property owner from physically mutilating their own property. It actually can also prevent this decontextualization of an artist's work, where perhaps the placement of that work or the potential, the partially covering of that work could harm an author's and artist's reputation. And I keep using author and artist interchangeably because the more expansive moral right of integrity allows not just a visual arts artist to raise a violation of the right of integrity, but also authors of literary works, musicians, songwriters of musical works. Outside of the U.S., the moral right of integrity generally protects much more works of authorship than just visual art.
Well, so maybe you could talk then a little bit about how these values are realized, or maybe not entirely realized, under U.S. law, specifically in the Visual Artists' Rights Act, or VERA, of 1990. Sort of like, what exactly is VERA? What was the context in which it was enacted? Sort of what does it actually do in relation to the right of integrity, both in terms of what it protects and how it protects it, and sort of and maybe even kind of in a broader, kind of more conceptual sense, like, what's the relationship between the kinds of things that Vera does and the kinds of things that the Copyright Act does more generally? In other words, why is it that Vera is sort of a unique element of the Copyright Act? How is it different from other aspects of the Copyright Act?
Right. So when the U.S. adopted FARA under its obligations under the Berne Convention, and during that time there was a lot of pushback for the adoption of any sort of moral rights in the United States for different reasons. Right. One of the reasons was that I think we have a very strong tradition of free expression, First Amendment right. Another big reason is this idea, this private property right that we have, that Vera definitely does, right, whittle away at the right to destroy, right, the right to mutilate a piece of property that maybe you own. And so how it would apply would be, I can purchase a piece of art, and I, as the property owner, could potentially be prevented from doing what I want with that piece of art, even though, right, under private property law, I own it, but the author still retains this sort of moral right of integrity to potentially prevent me from drawing a mustache on writer portrait, or somehow even creating, right, if we're talking about more expansive outside of the US, even potentially exhibiting it in an exhibit that the original artist finds offensive. Um, but but ultimately the U.S. did adopt VERA, and adopted sort of a much more limited set of moral rights, including moral right of attribution, moral right of integrity, and then this sort of stepchild of moral right of integrity, which was the moral right to prevent the destruction of works of recognized stature. Moral rights are considered much more limited in the US because not only did the US only adopt sort of these couple of moral rights, but also it only applies to one type of work, right? Work that's called the works of visual art or work of visual art. It includes other types of authorship, literary, dramatic, musical, audiovisual works. It also only protects single copies or limited edition copies of these visual artworks. And visual artworks has a very strict definition of being paintings, drawings, prints, sculptures, or still photograph images produced for exhibition purposes. And also, there are a lot of different exceptions in the US, some of them written into the VARA statutes, some of them interpreted by case law, including how the work of visual art does not include applied art, right? Does not include anything that is a work for hire. Courts have said, and one court has specifically has said, also it's site-specific art is excluded from it. It has to be separately eligible for copyright law. And so the US adopted a very much more narrow set of rights for the right of integrity. And I'm trying to see, and I think you also were looking at how is it different from Copyright Act. And one of the big differences, Copyright Act is typically considered an economic right, and applies to sort of intangible works, whereas at least the Visual Artists' Rights Act, it has been interpreted to apply to the destruction of a physical copy of the work, which copyright doesn't typically protect, right? Copyright is separate from the physical property right to a piece of work, whereas Visual Artists' Rights Act still attaches to that physical copy of the work.
Well, so your paper gets at a really, I think, interesting and provocative tension in VERA, which I honestly haven't really seen that many people engage with previously, which is one of the reasons that I found your paper really interesting and exciting. And specifically what you're talking about is the tension between the VERA right of integrity and the right of fair use, or the fair use doctrine, often considered sort of the most kind of important or sort of fundamental exception to the scope of copyright protection. And of course, VERA rights are subject to fair use, but there's some question about what that means. So, I wonder if you could talk a little bit about sort of what the fair use doctrine is intended to accomplish and why exactly you think the fair use doctrine is, at least potentially in tension with the protection of the right of integrity.
Yes. And so the way I like to describe the purpose of fair use doctrine, whether I don't know if everyone's going to agree with this, but it's to help find sort of a balance between an author's right in their expressive work that they've created, as well as the public's right, or a secondary artist or author's right to use that original work to create something further, right? To create something, create their own new expression, for instance. And the way I look at fair use is it's using these four factors that are in Section 107 of the Copyright Act in order to attempt to achieve that sort of balance. And fair use, right, is considered one of the main First Amendment safeguards that has been written into the Copyright Act, and has, I think, been used to allow secondary authors from using original works and creating new meanings, creating parodies of it, creating really cool secondary works that comment on or criticize the original works. There's definitely this tension between fair use and the right of integrity. And it's not, we see this sort of similar tension, I would think, when we talk about sort of the right of derivatives, an author's right to create derivatives, as well as fair use. And that is this, what is the integrity right meant to do, and what does fair use allow? Right? If the right of integrity is the right to prevent, right, modification, distortion, or mutilation of a piece of work. So, in other words, and some have described it as safeguarding that original artist's meaning or message in that work, then the secondary use of that work to as a parody, as a satire, or criticize, or using it in a transformative way, is going to somehow alter that author's meaning and message, right? To transform it is going to be to distort the original work. But it's precisely that transformation, that parody, that comment or criticism that would allow and give rise to this fair use defense as we understand it and interpret it now. And so a lot of people have looked at this conflict and felt that either fair use should not be applied to the right of integrity because it's going to completely gut the right of integrity and not give it any meaning, or the fact that there's this incompatibility should perhaps mean that we should get rid of the right of integrity because there's no way to properly balance it with fair use now. And so one of the reasons I wanted to write this paper was this really fun conflict that I wanted to explore. Right? You have this carve out in the statute for fair use, and yet it appears, at least on its face, to have this conflict, to be incompatible. And so that was one of the reasons why I wanted to explore, right? How can we contemplate working these two doctrines and together to make sure we are trying to strike a proper balance?
Well, so I'll confess that I'm one of those people who was kind of always under the impression that at the end of the day, the fair use exception to the right of integrity kind of had to render it almost meaningless. But in your piece, you give some examples of how the right of integrity can play out in practice and suggest some ways in which there might be still considerable room for balancing between these two kind of policy values. So, I mean, I wonder if you could talk about sort of how you sort of conceptualize the realization of the right of integrity in practice, and how you think we ought to think about fair use and the kind of values represented by fair use in relation to the right of integrity sort of in action, as it were.
Right. And so when I wrote this, I wanted to make sure that I captured this analysis broader than, right, what is currently protected under the Visual Artists' Rights Act. At the time I was writing this paper, the U.S. Copyright Office was doing a public study on whether or not current moral rights, Visual Artists' Rights Act basically properly protects the moral rights of authors in the United States. And for years now, there has been vocal push, I guess, vocal push to increase, expand moral rights in the U.S. And I thought it was important for me to not just address how fair use could work with the current application of Visual Artists' Rights Act, but also if moral rights were to be expanded in the U.S., how fair use, the four factors as we currently apply and conceive them, could potentially limit sort of a more expansive moral rights of integrity. And so the three categories that I ended up looking at were this first, which I call decontextualization, and inspired by the fearless girl sculpture that artists placed right in front of Charging Bull, right, completely reinterpreting Charging Bull. Charging Bull, I guess the artist, when he created it and when he actually put it in New York, right, guerrilla style, it was supposed to represent an uplifting message, right? It was during a downturn in Wall Street, and it was supposed to be uplifting American people. We can do this together. And then 20 years later, we have Fearless Girls right in front of it that completely reinterprets the Charging Bull. Right, shines a kind of a menacing light on the Charging Bull, while not physically mutilating, distorting, modifying Charging Bull. It definitely modified, distorted the message of Charging Bull. I wanted to that was the first category that I wanted to discuss, because even though under our current Visual Artists' Rights Act, that would not be considered a violation of right to integrity because of our public presentation example, other more expansive moral rights regimes, including the one that I described in Sweden, right, that would potentially be considered a violation. So I wanted to start with something that we felt comfortable with saying, okay, I'm comfortable applying fair use to something like this, where the original is not really distorted or touched or physically interacted with in any way. The second category that I wanted to discuss was this impermanent, temporary modification, distortion, or mutilation, which I used an example from Canada, which was the case, moral rights case,
I think it
where
was the Michael Snow one, wasn't it?
yes, thank you. Yes, I couldn't remember the name. Yeah, thanks. Where he created the sculpture of geese hung in a mall, and the mall decided over the holiday season they were going to tie these bright red ribbons on the necks of the geese. And Michael Snow claimed that was right a violation of his moral right of integrity. That impermanent distortion, while in the U.S. May not be considered a violation of the moral right of integrity, was considered a violation of the moral right of integrity in Canada. And if the U.S. were to expand moral rights to encompass more than just single copy Visual Artists' Rights Act, that would potentially be the type of violation that we would be looking at. If, for instance, we're talking about moral rights protecting music. And then the last one I think was probably the hardest one. Just because I think everybody, maybe almost everybody, but the idea of a original piece of art being distorted or changed or partially erased, I think naturally just puts a rock in everyone's stomach, right? A great piece of art that is no longer the way it used to be. But I wanted to make sure that I also addressed how fair use can be applied to instances which I use the term creative destruction in this law review article, how the four factors can be used to analyze creative destructions of works where it's an original piece, a limited edition piece that is physically mutilated by somebody in order to send a new message or create new meaning.
Well, so maybe you could talk a little bit about like sort of how that works in practice. Like in particular, I think the Fearless Girl piece is pretty well known. Like, if you were to look at that through kind of an American copyright fair use doctrine kind of lens, like how would you analyze that particular work from a fair use perspective in relation to the right of integrity, and sort of what kind of light do you think that kind of fair use values can shed on how we ought to think about that particular kind of intervention?
Right. Um, so under Charging Bull, in the Charging Bull and Fearless Girl scenario, right, we, if I were to apply the four fair use factors as they're currently analyzed and as they're currently conceived, right, I would be looking at the four factors under Section 107 of the Copyright Act. A lot of people have said that at least over the last decade, the most important factor seems to be looking at the purpose and character of the use, and in this case, it would be sort of the purpose and character of the secondary artist, the fearless girl, and how it may have transformed the original meaning of Charging Bull, making it something new, right? Making it a new work, giving it new meaning. And here, it seems pretty obvious that the fearless girl, by placing fearless girl, I can't remember, it was 5 or 7 feet in front of Charging Bull, completely transformed the meaning of Charging Bull, right? It almost updated the meaning of Charging Bull, highlighting this issue that we are talking about now and need to talk about more, which is the inequality of women, including inequality of gender inequality on Wall Street. And so sort of like that famous case, right, SunTrust, where Randall wrote The Wind Done Gone, transforming the meaning in the original Gone with the Winds. This is the same, I would argue that this did the same thing. Fearless Girl transformed the message and meaning of Charging Bull. It created this public dialogue between two sculptures. And I think that sort of public dialogue is important, right? And it is one of the purposes that we have fair use, to use an original work in order to create new meaning and public dialogue. And then going through the rest of the factors, right? Whether the work is the nature of the copyrighted work, right? How much was used, and then the effect on the use of the market. I think we see that if we were to take the traditional 4 factors of fair use, the way that courts have been applying them in copyright infringement cases, we would find that this use, had it been a violation of a right of integrity, would be considered a fair use. And I think that would be the correct, right, the conclusion in this case as well.
Well, so maybe you could talk about some of the other categories that you've mentioned. I'm particularly fond of the Michael Snow example because, as it happens, before I went to law school, I'm still very involved in the experimental film community, and Michael Snow is actually a very notable experimental filmmaker, in addition to being a sculptor. And interestingly, many of his films draw on material created by other people in a sort of sardonic or ironic kind of way, recontextualizing and reusing works that were created prior to his intervention. And so it's kind of interesting to think about him objecting, using the right of integrity in this context. And so I kind of wonder how you think about that particular complaint and how it was sort of understood by the Canadian court, and whether you agree with their sort of resolution of the question.
Right. That is interesting. Right. So I that sort of changes him as a character in my mind, knowing that side of his work. But so the Michael Snow, where he's suing Eaton Center for tying these big red ribbons on the geese. I thought it was interesting. The surrounding facts, I thought, were kind of important in that case when we're talking about fair use. Like, what was the reason of this mall decided to tie these red ribbons onto the geese? Were they trying to send, a new political message? Was it a social message? And so apparently during that time, the shopping center they were planning for its decoration in anticipation of holiday shopping season. And so, in addition to tying these red ribbons on the necks of the sculptures, they also created this whole advertising campaign around Michael Snow's beribboned geese, including creating posters, shopping bags, banners, right, all centered around Michael Snow's geese with big red ribbons tied around their necks. And so when I looked at this situation, first, again, according to legislative history, this was one example that was used to talk about what the public presentation exception would carve out from a violation of right of integrity. So according to legislative history, it sounds like the public presentation exception would make it so that this particular action in the U.S. under FARA would not be considered a right of integrity because it was temporary. But when I was looking at this case, I didn't 100% get to the conclusion that this would be, had it been a violation in the U.S. and had we applied the four fair use factors, that this would be considered fair use, right? What message was the mall trying to send? To me, it seemed like a purely commercial advertising campaign, which we know often leans away from fair use under the four fair use factors. And once you determine that perhaps the character of the use was not transformative, was purely commercial, then as we often see, the other fair use factors end up leaning away from fair use. And so if we had gotten to this analysis, I'm not positive this would have ultimately come down as being a fair use of Michael Snow's work.
So I found this particular example really interesting, right? Because it struck me that it's like, yeah, okay, the mall's use of the geese seems like it was pretty asinine. But I could totally imagine, say, Jeff Koons or Richard Prince producing like Michael Snow geese with ribbons and basically like lampooning Michael Snow as kind of this sanctimonious Canadian artist and like making fun of what he's doing by putting red ribbons around the goose's neck. I mean, would that be a fair use? And if it wouldn't be, would that be a problem?
I love that question because it's this idea of, right, if the same under the same actions, right, well, first of all, it gets to the fame factor, right, the fame question that a lot of my students like to dig into when we're talking about fair use. Who gets to win in fair use cases and who loses in fair use cases, and does it have anything to do with, right, how great an attorney or maybe an artist can craft a new message, meaning, and intent of their secondary use versus maybe an artist who does not have as much money to hire an attorney who can craft the most beautiful intent, message, meaning of what they were trying to do with an original work. But also, right, the intent of the secondary use matters, but also the expression, right, the expression that is created through that intent, I think also equally matters. I think looking solely at the intent of what I was trying to do with an original work, right, I can come up with any intention. I can say that I meant to express a message of a political message, an anti-whatever message. And yet, if the work that I created does not express a new message or meaning, right, should it be considered transformed for the purpose of the first factor of fair use? I do think fair use sees this, right? Fair use sees this problem when we're talking about just the normal copyright infringement cases. I think judges have had to attempt to read into the meaning of the secondary user, but also look at the underlying expressive content to see if it does indeed, in fact, create new message and meaning. And it seems like there's not always it's not always a slam dunk case for the argument. And I think I've gone off on what your specific question was. I got excited about the description part, which I always found really interesting, which is like, if you have a really good meaning, interpretation, and description in a court case of what you meant to do with your secondary work, right, are you more likely to win a fair use decision?
I mean, I guess part of it is like, in applying the fair use doctrine, should we be author centric
hmm.
in the lens or reader centric in the lens?
Can we be both? What do we think about attempting to be both author as well as reader centric, right? We can't, I don't think it's always fair, just because of some of the issues I guess I just went off on, right? It's not always fair to be always author centric, right? Secondary user centric. Because sometimes that can come down to how well you can describe what you're doing. And artists aren't always the best at putting their intent or meaning or message into words. And sometimes I would imagine that it's a good attorney who's really trying to interpret what an author or artist meant to do. Um, at the same time, right, if we're just purely work centric, then we have this problem of saying of judging art, right? Of saying, well, this work, who cares? The artist, the original author, secondary author, probably didn't even mean to create a new message and meaning, and yet I read message and meaning and everything. And so I would say maybe we could apply a balance in fair use where we're looking at both.
Well, I mean, it seems like this middle category is, in some respects, the hardest one to sort of cash out, precisely because of these competing speech values that you're talking about, and like sort of who controls the meaning. But there's a third category, which really goes to something, much more absolute, which is sort of like the destruction of works of authorship. And I wonder if you could talk about that a little bit as well, because I think that it's actually, for me, a really fascinating kind of aspect of the right of integrity, and one that is also hard to sort of cash out or understand how we ought to think about it, but maybe for slightly different reasons.
Right. So the third category was this permanent mutilation of an original or limited edition works, and this is currently under Visual Artists' Rights Act in the U.S. This is what is typically protected under the right of integrity, and to me, I think this one was the hardest, and one of the main reasons was I love art. Um, and the idea of a piece that I potentially would love and enjoy being permanently mutilated, I think that does just that made me uncomfortable, and I think it probably makes a lot of people uncomfortable to imagine that. At the same time, though, there is value, right? And there's value in works, and potentially original works, from being mutilated or modified to create new message and meaning. And sometimes that message and meaning can only be expressed by mutilating the original work or a limited edition of the original work to send that sort of message. And so in this section, I sort of devote quite a bit of it to talking about examples of this, right? Where the destruction, the mutilation, the distortion of the original work is what sends the message versus just taking a copy or a digital copy of it and making those changes. And I do think that this destruction can be important in sending political messages and sending social messages and often sending artistic messages. And looking at, right, does this then comfortably fit within the four factors of fair use? And I don't want to say that it comfortably fits within the four factors of fair use, but I think it can, there's a way to contemplate how to creatively, right, use the four factors in order to determine whether this secondary destruction or secondary modification furthers the social benefit of creating a new message or new expression.
Well, I wonder if you could talk about that briefly in the context of a few of the examples that you present in the paper. Like, I'm specifically thinking of the de Kooning Rauschenberg relationship, also the what was it, the Goya, I think, prints that were altered,
Yeah.
um, and then finally, the 5 Points Wolkoff case, which I find absolutely fascinating and really, obviously, quite timely as one of the few recent articulations of Vera in a really interesting context. So, in each of those cases, there's arguably a quote unquote destruction
Yeah.
of a work of authorship. Sort of, are they all the same, or should we think about them differently?
I actually think about them a little bit differently, because a lot of the examples that I have in this section, including right the Chapman brothers, the Goya Chapman brothers, as well as their series One Day You Will No Longer Be Loved, which used other original pieces, um, as well as Erase de Kooning. Those to me were mutilations. They were distortions. They were modifications. um, they weren't destructions of the work, but that they were meant to create something new. And so they weren't total burning down a sculpture, right? Although burning down a sculpture could be an interesting performance art. But they created a new piece that they then therefore exhibited as their own piece, as their own work. And so the case, right, the Chapman brothers, they continue to shock the world when they purchase, right, when they purchase these original copies or limited series. For instance, the Goya Disasters of War, very mint condition. It was described as mint condition, a limited edition prints, and decided to paint sort of clown faces on the images of agonizing people, in these images, in order to send a message of, right, the inadequacy of art as protest. Or their Chapman brothers, their series One Day You Will No Longer Be Loved was similar. They took 19th century portraits by unknown artists, unknown subjects, and then decided to alter them. And their message was to highlight society's attitude to the past as irrelevant and not worth remembering. We know that the erased de Kooning drawing also shocks the world, when Rauschenberg took 2 months to erase a de Kooning piece. That de Kooning actually sounds like he actually picked and chose to give to Rauschenberg in order to create this new expression, right? The message that he wanted to send was that the new art might be about its own failure to achieve greatness, its impotent rebellion against heroic past. Right, art is about its own destruction. And so, would these pieces fall comfortably under the 4 factors of fair use? Maybe. Right, these are. We know that the first factor under over the last decade has become the most important factor, oftentimes that courts looked at. Did they send a new artistic message in this sort of creative mutilation, creative destruction of these pieces? Yes, right. They've sent a new message through this creative distortion of the pieces. Once we know that there's a transformative use, we know that the second factor, whether the original works were expressive, creative, isn't as important anymore. We know that it's not as important anymore, that they used the entire work from the original author. I think the most uncomfortable fit in right of integrity and a fair use is this fourth factor, right, which is the market harm to their works, right? What do we mean about market harm to their works? If we're talking about the market harm to their copyright to the works, this destruction doesn't really do anything to that. In fact, it probably makes it more valuable, right? The original work is gone. Now, the only way you can see it is if you have, right, a reproduction of the work, and potentially increases the market value of reproductions or the copyright to this original mutilated work. At the same time, right, I do think that this fourth factor under this category of works is probably the least comfortable fit, but does not mean that it can't be creatively used to sort of apply to these right of integrity cases. I know you asked about the 5 points decision. Um, the 5 points decision I do bring up in the article, not just because it's sort of the most recent and most high profile recent moral rights decision, but it's interesting to think of, right? What if the developer did say, well, I meant to create a new meaning by whitewashing the 5 points street art. I meant to send a new message by doing that, right? How do we divide cases? How do we draw the line between cases where it's an artist or an author attempting to send a political, artistic, or social message versus it's somebody who wants to build a new apartment building in a place that's inconveniently is occupied by art, and now is coming up with a reason for its destruction. And I think that's where it's important to not just look at author's meaning, but also, right, readers' interpretation as well, balancing the two, as courts have done in fair use cases in the past, to figure out, right, what is there a new message? Is there the socially benefit work, extra additional secondary work that has been created from this violation of the right of integrity?
I mean, I will say though, especially in the Wolkoff case, I mean, I can't help but feel like, fuck you is a message.
From yeah, yes, in a way, right? Although he didn't do it until the preliminary injunction was denied, right? And I would think maybe that he knew that any sort of damages he would suffer in that case would pale in comparison to how much more he would have to spend to preserve sort of 5 points and then attempt to build a 100-story glass-clad modern apartment building on that site. And so maybe he had the fuck you message, or maybe it was just a really good financial decision that he was willing to sort of take a risk on.
A fair point. A fair point. Well, so Cathay, I mean, I wonder if in closing, you could reflect a little bit on what the tension between the right of publicity, or rather the right of integrity and fair use can or should tell us about sort of moral rights more generally and what we're trying to accomplish when we do moral rights. Because it seems like that's sort of the backstory of the entire paper for me. I mean, like, sort of like, what values are we trying to realize? And how does the tension that you're illuminating sort of help us better understand how we should think about those values?
Right. Um, I do think the message I want to send is that there needs to be sort of that there needs to be a fair balance. I know that I don't want to use this, and I was trying to be clear in the article at least, that I don't want to use this piece as saying we need to eliminate right of integrity because it absolutely conflicts with free expression. And also didn't really want to use this piece to try to fix fair use doctrine, right? Plenty of people have worked on fixes and criticisms of, or not criticisms of fair use doctrine. And that really wasn't the point of this piece either. I wanted to look at the importance of, right, the dignity type rights in people's work, and yet understand that there has to be limits, just like copyright has limits. The right integrity has to have limits as well. Right? Just like you can use words to criticize someone, you should also potentially be able to use their works of art to criticize or comment upon their works, or comment or criticize the authors of those works, and really wanted to contemplate sort of how this defense, without changing it as it's currently being applied and interpreted by courts, how it can and should potentially limit moral right of integrity, especially if we are seriously discussing and considering expanding moral rights in the US. I don't think we can do that responsibly, expand moral rights in the US responsibly, without really starting a very serious discussion about how fair use would apply and whether fair use is enough to safeguard free expression and secondary users, as well as the public's right to expression, if we are to expand the right of integrity as well as moral rights generally.
Well, thank you so much for coming on the show. This is a great conversation. I really enjoyed this paper a lot, and it got me thinking, obviously, and I'm really looking forward to reading more of your work on the subject in the future.
Thank you, Brian. It's been great chatting.
There once lived a bull, a magnificent bull, in a pasture near old Barcelona.
Baloney.
He would romp and he'd play through the flowers all day, till he'd smell just like eau de cologne.
Baloney.
He was gentle and kind, and his moo was refined, which the rest of the bulls all resented. For when he'd start to moo in a moment or two, he'd have all the cows discontented. Ferdinand, Ferdinand, the bull with a delicate ego. Ferdinand, Ferdinand, the heifers all called him amigo. Ferdinand, Ferdinand, he'd curtsy and greet them politely. Now he knew how to tango and dance the fandango, but he never learned to fight.
Woo woo! My time, Ken. Your time, Ezzy. Now there once lived to be a magnificent bee who was feeling so chock full of vigor that he got out of hand and he stung Ferdinand with his sharp little thingamajigger. Now Ferdinand was so hurt he was pawing the dirt when a bold picador chanced to sight him. Ah, the picador cried, as a matter of pride, I'll get out my stiletto and I'll fight him.
Ferdinand, Ferdinand,
Ferdinand,
he smiled when the picador faced him. Ferdinand, Ferdinand,
oh Ferdinand,
he winked and the picador chased him. Ferdinand, Ferdinand, he viewed the occasion so lightly. When the picador missed him,
why Ferdinand kissed me,
for he never learned to fight.